Well, hello and welcome to the review for exam number 4. You have the untied instructor today. This is the weekend. It is currently Sunday, December the 3rd, and I thought I should upload a review for you in as much as we have exam number 4 coming up on Wednesday. You should be pretty familiar with the format of the exams at this point in time. Let me specify, however, that part A of the exam, the objective questions, of which there will be 25 objective questions, each worth 2 points, that will open up at 8 a.m. on Wednesday. That will close at 8 p.m. on Wednesday. So give yourself enough time to be able to complete those 25 objective questions. Part B of the exam will open at 8 a.m. on Wednesday, and that will actually close at 11:59 p.m. on Thursday. So a little bit of additional time over and above what you had for the first 3 exams. But I also want to specify for you that on this exam number 4, it is an exam number 4. It is going to cover all the material that we had from exam number 3 through the last of the substantive material, which is labor law. There is not a final exam. There is a 4th exam, but I have received some emails from some of you, I think, wanting to be cautious and make sure that you weren't missing something for purposes of a final exam. There is a 4th exam, same format as exams 1, 2, and 3. I have uploaded for you a review sheet. I have managed to, I think, get most of the content that is on that review sheet onto exam number 4 in one form or another. I do not intend for this review to be a complete restating of that which we have covered. But I do think that it is helpful for you perhaps to hear from me one last time as to what I think is important about each of these different topics. I think it's a fairly even mix between questions and points relative to the topic of business organizations, and with a kind of an emphasis on corporations on that portion of the exam, and employment law in the employment discrimination statutes. I think a little bit more application when it comes to employment law, perhaps a little bit more definition when the question involves business organizations. A couple of questions as it pertains to the labor statutes, and I'll get into that in just a moment. A word of warning, a word of caution, a word of thought as you approach, but again, another set of final exams. Try to make sure you get adequate rest. The older I get, the more reflective I am, the more I have interacted with students. You perform better. Certainly, you are healthier if you get adequate rest. And so it should be a point in each day where perhaps you just call it for the day and start up again the next day. I get emails from you at all hours of the day, sometimes quite late. And if I could go back and tell my Michigan State college-aged self a thing or two, I guess one of the things that I would tell myself is it works out. So a lot of the anxiousness that I felt when I was your ages, it has a way of working out. And I probably would also remind myself to enjoy it maybe a little bit more and focus in on getting adequate rest. All things that come perhaps with age, but things that if I could go back and have a little bit of a redo, I might do those a little bit differently. So for what it's worth, I offer you those thoughts. Since I can't redo, but you're in the middle of going through all of that. I know that anxiousness ratchets up a little bit during the first couple of days and certainly week of December. You got due dates, you got exams, you got lectures, you got papers. Keep perspective, do your best. That's all you can ask of yourself. If you are in jeopardy of failing the course, I will reach out to you and let you know that you're not. Certainly the vast majority of you that are listening to this. And in fact, I'm very optimistic that for some of you, you'll finish up really well. The only promise that I can make to you is you'll get the grade you deserve or better. Let's try to put you in a position where you're going to succeed on the fourth exam. The content on the fourth exam, as I indicated, is primarily a even mix between business associations, employment law, and then a little bit of labor law sprinkled in at the end. There are more topics certainly to be prepared for on exam number 4 than you saw on exam number 3 or exam number 2. But I don't think anything is that difficult in this material. There's just a little bit more of it. To me, a key to success on the business association's business enterprise portion of the exam is to be able to distinguish one business enterprise from another. We talked about the main business organizations as being the sole proprietorship, the corporation, and the partnership. And one of the key features, one of the key distinctions between those is how we treat those business entities with regard to the concept of liability. If there is a lawsuit based on a breach of contract or a violation of a statute or a tort that is committed, certainly there is a significant difference between if the business is constituted as a corporation as opposed to when the business is engaged in as a sole proprietorship. The sole proprietorship is you and I. It's the individual when we are not acting in a representative or employment capacity on behalf of another. We are by default a sole proprietor if we have not incorporated, if we have not created some form of business structure and sought the concept of corporate protection as established by estate governance. If we've not filed articles of incorporation, if we are engaged in business, not in the capacity as an employer agent of another, by default, we are considered to be a sole proprietor. And the overriding feature, the characteristic of the sole proprietorship is unlimited personal liability, because there's no distinction between ourselves and the business, which is why, as we discussed, if we are going to engage in business over a prolonged period, or if we are concerned about protecting assets, the loss of assets because of liability issues, it would be wise for us to incorporate. We incorporated business by filing articles of incorporation with the state, having those articles of incorporation accepted by the state, creating the entity that is separate and distinct from its owners, its employees, its managers, its directors, the corporation. So long as we engage in business as a corporation, so long as we let those whom we are engaged in business with know that we are acting as a corporation, we are entitled to the shield of corporate protection, protecting ourselves personally from losses other than what we contribute to in the operation of the corporation. The risk of loss is our investment, not our personal fortune, our personal wealth. And one of the things that we talked about was the distinction between liability issues for those who operate business in a corporate capacity as opposed to those who engage in a business transaction as a sole proprietor or as a partner in a partnership. The distinction between the sole proprietorship, the corporation, the partnership, what type of business enterprise exists is determined at the state level of lawmaking authority. And within the classification of corporation, there are sub-classifications, ways that we look at corporations that I think are important to understand. I have presented those to you in lecture. I have presented to those to you in the lecture slides. But certainly you'd want to know what the features, the characteristics of a corporation that is classified as a C Corp for purposes of tax liability, as opposed to an S Corp, where we pass through the earnings to the individual shareholders and tax those earnings at the individual shareholder rate, rather than if the classification is a C corporation and the earnings are taxed at the corporate level, and then that which is passed through are taxed the second time at the shareholder level. We talked about the distinction between the corporation and the professional corporation. When a licensed professional, a lawyer, doctor, engineer, accountant, a dentist, doctor, operates a business and has incorporated that business, that licensed professional still faces unlimited personal liability for the acts of malpractice, negligence that he or she or they have engaged in. The fact that one incorporates doesn't shield that professional from professional liability. Whereas when they operate as a professional corporation, they are entitled to the same shield of protection that corporate owners have, other than the professional and his or her or their acts of professional negligence, which they are personally responsible for and cannot shield. We also talked about the concept of the corporate shield, the corporate protection existing when a good faith effort has been made to incorporate. We refer to this as a de facto corporation if there is a failure in some respect in the establishment of the corporate shield, the corporate protection, but a good faith effort has been made to incorporate. Whereas if a corporation has been fully satisfying the statutes for the creation, the establishment of a corporation, we refer to this as the de jure corporation. The concept of piercing the corporate veil, holding the owners, directors, employees responsible for the debt, the liability of the corporation, is something that doesn't happen often. And in fact, it's the exception that really kind of proves the significance of the rule. The piercing of the corporate veil exists where the corporation really exists for the purpose of engaging in unlawful or unethical acts. The Bernard Madoff circumstance, where the corporation itself was out committing illegal acts, and the owner of the corporation or owners of the corporation faced personal liability. That is an exception and certainly not the norm. We talked about partnerships, and what I want to just highlight on partnerships is, again, the concept of personal liability for business partners, but not just limited to personal liability for one's own acts, but also for the acts of the other partners relative to the conduct of that joint enterprise, that partnership. The law really enforces partnership concepts when, in default, there is the possibility of liability amongst multiple people, and those multiple people have not incorporated their collective activity. If you have 2 or 3 or 4 people that are engaged in an enterprise and they have not incorporated, and the likelihood is they wouldn't be able to actually engage in the conduct of that enterprise without each other. Again, think of 2 or 3 people that rent a house together when they're attending college. the law of partnership applies such that each of them is responsible for their own liability, but they're also responsible for the liability of one another. It is not the preferred method of engaging in business. Certainly, when possible, one will incorporate and make shareholders rather than partners out of those whom they are collectively engaged in business with. I think of the sole proprietorship as having two or more, I think of the partnership. Excuse what I just said. I think of the partnership as existing where you have two or more sole proprietors together. They face unlimited personal liability for the totality of the acts of that joint enterprise, that partnership. Also, partnership law applies where you have two or more people engaged in an activity, and there becomes a question of how profits will be divided. Absent an agreement to the contrary that can be enforced, if you have two or three people that are involved in an enterprise together, and there is now the question of how to divide up profits, profits will be divided equally amongst those who are deemed to be partners in that enterprise. Probably the area of law that is going to make or break your success on exam 4 is how you successfully apply the concepts of employment law to the fact patterns that you're going to get on the exam. Much like what they call handicapping on a golf card that tells you the more complicated holes from the easier holes on a golf scorecard. I look at the exam and I, in putting the exam together, know what are the kind of easier questions from probably the more challenging questions. And the more challenging questions, I believe, on exam number 4 are fact patterns that are seeking to test your ability to understand the concepts of employment law and employment discrimination. What do you need to be thinking of? How do you apply the law to facts in the area of employment? I think, as we discussed, employment law should be viewed the following ways. The role of employment law is the application of contract law, because that's what the employment relationship is. It's a contractual relationship between employer and employee that is then an area of contract law that we regulate because of the significance of the employment relationship. Suffice it to say that there are few contracts that you enter into that will be as significant as the employment contract. Again, for those of us that are not independently wealthy, that need to make money to sustain our lives, we need the livelihood that our employment brings. The necessity of regulating these types of contracts is important and recognized. And so we have the freedom of contract. We allow for employers to pick and choose whom it is that they want to hire and fire and promote and demote. But we say then to those employers, there's certain aspects of the human condition that you cannot utilize in making the decision on who to hire and fire and promote and demote or even interview. So we have the Equal Pay Act of 1963 that says, hey, if a man and a woman are doing substantially the same job, they're to be paid the same. We have the Civil Rights Act of 1964 that specifies is that employers that have 15 or more employees can't use race, religion, color, sex, national origin as a factor in hiring, firing, promoting, demoting. We have age, we have disability, statutes. We have pregnancy protection statutes. We have case law that interprets these statutes to be inclusive of sexual orientation and prohibiting sexual harassment as a condition of employment. So we have the freedom of contract. We get to hire and pay and promote and demote and fire at will, but we regulate that freedom of contract by placing certain restrictions on employers. And those restrictions are inclusive of all of the statutes that we talked about and that are reflected in the lecture slides, including some of the state discrimination statutes, notably the Elliott-Larsen Civil Rights Act in Michigan that prohibit discrimination on the basis of marital status, height, weight, and as I indicated previously, sexual orientation. When you look at employment cases, when you look at employment fact patterns on the question, I think it is important to recognize that the employment contract is going to fall into one of three different types. There's three different types of employment contracts. The employment contract that is for a fixed term, the employment contract that is what we refer to as the at-will employment relationship or employment contract, and then what we refer to as the for cause or just cause employment contract. Always be cognizant, always look, always know what type of employment contract exists. The presumption, the fallback, the backdrop is that it's going to be an employment at will contract. That's the way that most employment contracts are characterized. A fixed term employment contract is an employment contract that we know exactly when it's going to end. It likely may include certain provisions that allow for termination of the contract prior to its end date, usually for reasons that can be justified as being for cause reasons for ending the contract. But when it's a fixed term contract, you know not only when it starts, but you know when it ends. The most common employment contract, the contract you shall always and should always presume exists, is the employment contract that is deemed or characterized as being an at-will employment contract. Oftentimes when you ask somebody, what's an at-will employment contract, they'll tell you, well, it's the type of contract that the employer can end. They can fire you for no reason whatsoever, as long as it's not an unlawful reason. Actually, the employment at will contract is broader than that. It applies to all aspects of the employment relationship: who you interview, who gets hired, who gets promoted, rate of pay. And indeed, the presumption is that the employer is permitted to make decisions that are presumed to be lawful. And the burden of persuasion is upon the affected employee or would-be employee to show that the employer has acted unlawfully. This is what makes employment discrimination cases so difficult. The burden of persuasion, the burden of proving that the employer has acted unlawfully, rests with the employee or would-be employee that believes that they have been unlawfully discriminated against. While we recognize, understandably, that the concept of employment discrimination has a very negative connotation to it, there's a marked difference, incredibly important distinction between discrimination and unlawful discrimination. Is it permissible for an employer to discriminate? Absolutely. What is not permissible is for an employer to unlawfully discriminate. I fire an employee because the employee is 27 years of age and I think that's just too old for the job. That's discrimination on the basis of age. But it's not presumptively unlawful discrimination on the basis of age, because the Age Discrimination in Employment Act protects employees from age discrimination at age 40. But even there, as you may recall, the defense of, well, there's another non-unlawfully discriminatory reason for terminating the employee that allows for oftentimes the employer to prevail, even when on its face, it appears that the employer has acted unlawfully. We fired the 62-year-old not because he or she or they was 62 years of age, but because we were able to bring in a 38-year-old at far less of an expense, and it wasn't an age issue, it's a money issue. That's a defense that courts have typically accepted. So you look at the employment contract with a recognition of that it's most likely a employment at will contract, which means that the employer would have to establish that the employee would have to establish that the employer has acted unlawfully. And that's where you'll want to look at the facts and apply the law to those facts. If it's about pay differentiation, you're going to want to look at the Equal Pay Act or the Civil Rights Act. If it's about termination of employment, you're going to probably want to look at the Civil Rights Act as inclusive of the Age Discrimination Act and the Disability Act, and perhaps even the State Civil Rights Act. The for cause or just cause employment contract is where the employer chooses to give up the presumption of at-will employment, and the employer takes upon itself the burden of establishing that the reason for taking a position that is adverse to the employee was for a legitimate, justified reason. It shifts the burden of persuasion to the employer to justify the decisions made by the employer. I selected employee A over employee B. I can justify my decision for the following reasons. I terminated employee C because employee C engaged in behavior that I did not wish to tolerate. I can justify that decision based on the following. If it's an employment at will scenario, I don't have to justify as the employer my conduct until or unless the employee is able to establish that I have acted unlawfully. Then I got to defend it. I didn't act unlawfully. Or there are legal justifications for discriminating on its face against or in violation of the statute. Modified occupational qualification, merit, seniority, being some of the defenses. But if it's a for-cause employment relationship, the burden is on the employer to establish the legitimacy of the decisions that he or she or it made. I'm not going to go through the statutes because those are available for you, and I've done that. But I am going to suggest to you that when you look at a fact pattern concerning or about employment, you've got to go through that kind of progression of thought. What type of employment contract is it? In other words, who bears the burden of establishing that there is unlawful conduct on the part of the employer? Is there a defense? What is that defense? What is the likely outcome going to be of that particular case scenario? And again, the statutes have been construed by the courts in detailing what is meant by the enactment of those statutes. Gender discrimination. Through the years, the courts have applied the rationale that as having a gender, as having a sex, is also inclusive of having a sexual orientation. It's inclusive of having a respect that we're entitled to as employees, not to have as a condition of employment our sexuality. So we have the sexual harassment line of cases that prohibit hostile work environment or prohibit quid pro quo sexual harassment. We also have the cases that view the Civil Rights Act of 1964 as being inclusive of sexual identity and sexual orientation. The interpretation of these statutes by the courts have broadened the protections that employees have. They haven't changed the burden of persuasion as being with the employee to establish that the employer has acted unlawfully. But the purpose of these laws and the interpretation of these laws is really to also foster the actions and decisions on the part of employers to not be unlawful. It's where I have suggested that many of these statutes do not actually provide a great amount of protection for employees, but they do set the standard whereby employers will make decisions that are at the macro level, setting forth a policy and a culture that hopefully will foster non-unlawfully discriminatory practices within that employer-employee relationship. We're not there yet, but certainly that is an objective that exists within the law of employment discrimination. We talked about also the concept of disparate treatment and disparate impact, how we go about establishing if there has been unlawful discrimination. Disparate treatment is unlawful discrimination on its face. Disparate impact, well, you'll have certain what appear to be neutral policies that if you combine them have the impact of being unlawfully discriminatory against an individual or classification of individuals. Lastly, we talked about some of the other concepts within employment law, such as the Equal Employment Opportunity Commission, the Michigan Civil Rights Department, the governmental entities that you can turn to make a claim and ask for an investigation when you believe that there has been unlawful discrimination within employment. We talked about the remedies that exist, inclusive of attorney fees if you're able to establish that you have been unlawfully discriminated against. And we talked about, the public policy types of cases like the whistleblower cases, where someone steps forward and does what as a society we wish for them to have done and has suffered some form of retaliation as a result of that. And we offer them the protection of discrimination law and inclusive of reinstatement to their job position if they can establish that they are the victim of public policy violation. Finally, we talked a bit about labor law, and I introduced you to the labor concept, and that is where groups of similarly situated employees will negotiate the terms and conditions of their employment contracts as a group. This offers particularly those who are in or viewed as being in less skilled employment the power of collective action. I alone have limited power, but acting collectively with 10 or 20 or 100 or 1,000 others can negotiate a better term and condition of employment. Under the National Labor Relations Act, also known as the Wagner Act, the legal right to bargain collectively as a group was established. We also established the National Labor Relations Board to enforce the rights of similarly situated employees who wish to negotiate the terms and conditions of their employment contracts as a group. The law has been amended multiple times. The Taft-Hartley Act created certain rights of employers to enforce collective bargaining agreements against labor unions. And then the Landrum-Griffin Act that establishes certain rights for employees against perceived or potential abuses of their own labor unions. Not much on the exam, but certainly worthy of looking at the lecture slides on those statutes. I also concluded by talking about the mandatory bargaining topics, wages, safety measures, all of the facets of the contract that we would consider to be essential to the employment contract. There is a responsibility on both the labor union and the employer to bargain in good faith the terms and conditions of employment. And then finally, the so-called right to work laws, wherein if an employee is benefited by a union negotiated contract, can there be a mandatory requirement that the employees who have benefited by that union contract be required to pay dues for having been the beneficiaries of that contract negotiated by a labor union? In the so-called right to work law states, compulsory payment of union dues cannot be mandated. In states, in Michigan has now been both. If you are the beneficiary of a negotiated contract by a labor union, there can be a requirement that a payment be made by that employee relative to dues associated with the negotiation of that contract. Other than just understanding the concept itself broadly, not much on the exam as it relates to any of the labor law concepts. I think where you're going to want to focus your time in preparation is the big picture of employment law. The three different types or categories of employment contracts: fixed term, for cause, and most significantly, the at-will employment contract. And then, if you will, how we have certain inroads, certain exceptions by enacting statutes that say to employers, yes, you can discriminate, but you cannot discriminate on the basis of these different factors, inclusive of everything from race, color, religion, sex, national origin, all the way through age, disability status, as I indicated, pregnancy, sexual orientation, sexual identity, and the like. I am not concerned about the dates on the statutes. I am not concerned about the numbers of employees that an employer has to have for the law to apply to them. So the fact that the Age Discrimination Employment Act is 20 employees, where the Civil Rights Act of 1964 is 15 employees, for the employer to be bound by that law, I don't care. A lot of it was just where and how many employers were going to be impacted at the time the law was enacted. But I'm not, this is hopefully not a trivia type of exam. I'm not concerned about dates. I'm not concerned about those types of numbers. Again, perspective. Inevitably, there are going to be people that don't feel well. Reach out and tell them. Inevitably, there are going to be people that have computer glitches. Reach out and communicate that with them. There are some of you that have not yet taken makeups for exam 1, 2, 3. We've got time. We're going to get to that. Be patient. Let's focus in on exam number 4. And then those of you that have and are in need of makeup exams, we will tackle that after exam number 4 and during final exam week. I'm around. If you don't get a response to an email, send it again, because I really try very, very hard to respond to emails. Office hours are going to be a little bit different this week because I have got a commitment that is going to take me away. But I'm here to help. We exist as a university because of you, for you. That's our mission. But make sure that you exist also, at least in part, to help and assist others. Don't let this day go by. Don't let any day go by where you don't reach out and try to just make somebody else's life a little bit better. And it doesn't have to be going and giving, bone marrow. All right. It can just simply be the thoughtfulness of a text, an email, a hello, a call. A lot of loneliness out there that people suffer. And that's on the rest of us to make inroads towards helping. And I have to remind myself of that, but I remind you, if there's anything I can do for you, reach out. But at the same point in time, recognize that as anxious as you are about things, there are people that absolutely are struggling far more. And be there for those folks. When you see me now and in the future on campus or in East Lansing, please say hello. I really like when people come up and tell me, hey, I had you or have you as an instructor. It means a lot. Was unshaven, unshowered, saw somebody at McDonald's about 3 hours ago, was a little embarrassed about my look, but I still liked a student coming up and saying hello. Have a good week, get some rest, have a great break. Make sure you get rejuvenated over the course of the break. Those of you that are graduating, congratulations. Those of you that will be back in 2024, let's make it a great 2024. And as always, go green.